Stand right here, face the clerk, and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can be seated. You'll
Thank
speak into the microphone in front of you. You can move it if you need to.
Okay, thank you.
Ma'am, can you tell the court your name?
My name is Rochelle Dial.
What do you do for a living?
So I work at a furniture store. I'm Hank's Fine Furniture, and I'm an office manager.
How long have you been doing that?
2 years.
Now, how do you know Mr. Lovejoy?
He actually applied for a job at Hank's, and I filed the paperwork, and that's how we met at work.
What kind of job did he have at Hank's?
Warehouse.
Okay.
And he did other odds and ends around. Whatever needed to be done, he did that.
Prior to him applying for a job there, did you know who he was?
No, I did not.
Now, do you have any concerns if Mr. Lovejoy was released on bond?
Oh, no, not at all.
Why not?
Because to me, working, he's been a great person. He hasn't showed anything like suspicious or anything like that. He's always been a helpful person, always smiling, always a loving person. Always talked about his daughter when we had conversations, and then that's it. And did as he was asked at work, so no.
When he was working at Hank's and you were there, did you guys run into each other a lot during the course of a day? Or?
Yes, well, at first, he was a little quiet at first. He was a little reserved. And I was like, listen, you work here, you got to be, we're all family here, and we all are family. So I was like, you got to come out of his shell. And as he got comfortable, he came out of his shell. He would come to the counter and talk, and we would conversate. We had teen nights that we had on Sundays. So after work, we would go bowling. And I was like, you should come out. His first time, I was like, you should come out and hang out with us like that. I said, that's normal what we do. It's like a team building night. And he actually showed up and shocked us all. He showed up and hit a strike that we named the J shot. It would be always called the J shot, and we still talk about it to this day.
Is there anything else you want the court to know about Mr. Lovejoy and his role at Hank's, or how you know him? Anything else that you think the court needs to know about?
I'm sorry.
Go ahead.
Yes, that he is a family-oriented person. He loves family. He talks about his grandma a lot. He talks about his daughter a lot, and just a loving person. I feel like even there were times where his car had broke down. He did not call in. He could have called in and not came to work from where he stayed at. He drove all the way to Destin to work. Well, I think he rode a bike. He told me he got on the bike. He was like, do you need a ride back? We can take you. He was like, no, I got it. I got a ride back. But he actually came and was very dependable and reliable and would do anything we asked. It was always, yes, ma'am, yes, sir, and proceeded to do whatever was needed. Great help. We truly missed him. So.
Okay. I don't have any other questions.
Okay.
To the state?
No, the state has no questions, Your Honor.
Thank you, ma'am. Thank you, Ms. Goss. Thanks for being here.
You're welcome. Thank you. Thank you very much.
Mr. Kleins, any other evidence?
I'm just going to take some very brief testimony from Mr. Lovejoy.
Okay. Mr. Lovejoy, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Mr. Lovejoy, when you were first arrested, did you hire a private attorney?
Yes, sir.
How much money did you pay for that private attorney?
$8,000, and then my grandma added an extra 2, so 10.
Okay. Would it be fair to say that that kind of depleted any available funds that you would have had for bond?
Yes, sir.
Okay. Could you afford a $150,000 bond right now?
No, sir.
Why are you asking the court to reduce this to a signature bond?
Due to the fact that I've been here in a year and I haven't made no money. My people don't have no money. So.
Would you be willing, if the court granted this motion to reduce bond, would you be willing to abide by, let's say, community control sanctions?
Yes, sir.
Would you be willing to abide by a GPS monitor?
Yes, sir.
I don't have any other questions.
Questions from the state?
I have no other questions, Your Honor, or no questions, Your Honor.
Okay. Mr. Kleins, argument?
Yes, sir, Your Honor. So I came onto this case a year into the case's existence. Mr. Lovejoy was arrested on July 30th of 2023. I was appointed at docket day on July 8th, 2024. There was a previous bond motion filed for Mr. Lovejoy by his privately retained attorney. I did go over the motion with Mr. Lovejoy, and I don't know what happened in that prior hearing. If I saw it, I didn't retain any of it, so I don't know if the court's getting new information today. But just the written motion seemed pretty inadequate, as specifically Mr. Lovejoy identified, because I asked him about the medical condition that was mentioned in the prior bond motion. He's like, I don't even know why that, I don't have a medical condition. I don't know what that even is in there for. Mr. Lovejoy's grandmother was present this morning. I talked to her myself. I was half expecting her to, I was actually fully expecting her to be back today. I was going to put her on the stand because that's where Mr. Lovejoy would be living if he's released on bond, is with her at 37 Holmes Boulevard. He's lived in that house his entire life. He went to Fort Walton Beach High School. Ms. Dial referenced his daughter. In the motion, it sounds, I didn't ask her, but I asked her out in the hall. She thinks that he could get his job back. She's not 100% sure. She doesn't make those decisions. But he potentially would have employment waiting for him. When I got the case, Your Honor, no depositions have been taken to date. I mean, they're scheduled for October 8th. The only reason, and I know it's a steep request, and these are serious charges, to ask to reduce something currently set at a six-figure bond, to reduce it to signature bonds. The reason is because he's been in custody since July 30th of last year. He doesn't have any money. He spent $10,000 on his attorney who didn't take a single deposition. I don't understand how it took me 3 months to get depositions scheduled and it couldn't happen in 12 with the previous attorney. So these are, as I said, serious charges. I did look at Mr. Lovejoy's prior record. The battery on a law enforcement officer on the score sheet is from 2014. The aggravated assault by threat is from 2013. And not having delved super deep into it, that battery on law enforcement is actually battery on an officer at the jail. I'm assuming that he was in jail for the 13 CF case when he picked up the 14 CF case. Other than that, he's just got misdemeanors on his priors. 2 of them are failures to appear. But he has testified today he would be willing to abide by community control sanctions. Intensive in-person reporting to pretrial services I think would be in order given the nature of the charge. And a GPS monitor if the court is that concerned about the safety of the community. I can tell the court, having talked with Mr. Lovejoy, the alleged victim in this case is Mr. Lovejoy's sister's baby daddy, for lack of a better way of saying it. I mean, this is a family-type situation here. And I don't know what is going to come out of the depositions, but given the length of time he's waited in jail for anything to happen on this case, he is requesting the court to consider reducing these to signature bonds.
To the state?
Yes, Your Honor. What Mr. Kleins had stated is correct. I just want that to be known. In terms of the prior record, I mean, the 2 charges that I think would stick out to this court did occur, one about a decade ago, 2014, the other one in 2013. There are 2 prior FTAs, 2013 and 2012. Those are misdemeanor FTAs, not felony FTAs. So I do want to acknowledge that those were quite some time ago. However, I do want to point out, that was an aggravated assault with a deadly weapon in 2013 as well. In this scenario, one of the main things I want to point out, and I think this will be fleshed out in depositions, is that based on the statements made by the victim on scene, one of the things that sticks out in terms of the safety of the public for us is that Mariah, who was the defendant's sister in this case, and the I guess baby mama, for lack of better words, of the victim, was holding Ariella, which was a juvenile, about 5 to 10 feet away from where the victim was standing at this time when the alleged shot was fired. I think that I understand Mr. Kleins' position that, had some things been differently with private counsel, this case would have been maybe in a different posture as of right now, possibly even resolved. I don't think that negates what the allegations are. Having spoken with the victim, he is very adamant. He's in constant contact with our office, and so I know that he is against any sort of bond reduction at this time. I think given the allegations that, this was a loaded firearm that was pointed at an individual and then a shot was fired, I think that the amount that's been given on the bond is more than reasonable. However, if this court is inclined to reduce it, I still think that it should be a cash professional bond at the very least. I mean, the state is adamantly requesting that this bond remain as it is and not be reduced. However, if this court does feel inclined to reduce the bond, we do want a cash professional bond, not a signature bond, because, I mean, this is a situation where there was other people involved, there was a kid nearby, and so for those reasons, Your Honor, we respectfully request that this bond remain in place as it is.
In addition to the cash or professional, what other terms were on the bond?
I don't think he was even ordered to be on pretrial services. I have on the first appearance paperwork, I think this is my mark that I had circled B for moderate supervision, I believe. I don't think that pretrial services was ordered. I think it would definitely be appropriate, given the nature of the charge here. I will tell the court, Mr. Lovejoy just wanted the court to know that the alleged victim in this case potentially was intoxicated at the time, and Mr. Lovejoy disputes that there was a child nearby. That's yet to be determined. But.
Okay. Mr. Lovejoy, first, the easy thing for the court to say. I don't think you could have gotten a better character witness than you did of Ms. Giles. Very enthusiastic. Everything that she said helps you a lot. What has happened to you over the last year, when I did my homework in line 1, and I'm sure Mr. Klein's put it there intentionally, Mr. Lovejoy was arrested in this case on July 30th, and I circled 2023. Huge, stands out. It's a long time. I don't need to tell you that. As I look at the addendum to the probable cause affidavit, and so what has happened to you over the last year, if the state was the reason why there was this big delay, then it may be a different outcome. But because I don't see any fault with the state for that, and because of the allegations of, and I'll just read the one sentence, the defendant loaded the firearm in front of the victim, pointed in the direction of the victim, and pulled the trigger, firing one round in the direction of the victim. Because of that allegation, and that's the only evidence I have other than Ms. Kyle's testimony. Your motion for bond reduction is denied. However, the court does modify that bond to require community control sanctions if you do post the bond, a GPS monitor, appoint pretrial intervention, have no contact with the alleged victim, and intensive pretrial supervision. Will I see Mr. Lovejoy on November 12th?
Yes, Your Honor.
Okay.
It's still 160.
You're, oh, yes.
You can speak, just don't talk.
I mean, so I can't say that,
Why don't me and you talk about it? I'm going to come see you before these depots. The depots take place in 2 weeks.
Thank you, Ms. Kyles, for being here.
yes, sir.
All right, so I'll come talk to you at the jail next week. And I'll talk about these depots.
Yeah, but I would like to ask you some questions.
You're an adult. If you want to talk to him, talk to him. I don't advise it.
Yeah. Hey, Your Honor, if I may say something, Your Honor.
Just know that everything's being
Yes, sir.
recorded.
I just feel like during the whole case, on Your Honor, they said that I had a firearm, but I never had a firearm, Your Honor. When I was arrested with possession of a firearm, there was never a firearm in my possession.
Okay. And Mr. Kleins will get evidence at those depositions. And if he finds something that is substantially different, he certainly can file another motion for bond. Okay?
Yes, sir.
Thank you.
Okay, I'll see you next week. Yeah, no, I'll turn it over to Mr. Koch. I think he's going to have a police probation.
Mr. Koch?
Judge, if we call Mr. Antoine Ridge, who's present and approaching. This was on the arraignment docket, Your
Okay,
Honor.
thank you. Hello, Mr. Ridge.
And Your Honor, Mr. Ridge had Mr. Steve Medina in Judge Ketchell's division, and Mr. Ridge pled out 3 cases already in Judge Ketchell's division for probation. I'm not sure why this case got transferred down, but it's going to be a plea that runs concurrent with those cases. If I may approach with the plea form.
Yes, sir. Thank you.
And currently, I'm not appointed, Your Honor, in this case. I did go over the plea form. I've spoken with the state and probation. I'm requesting not to be put on this case just to save Mr. Ridge that $150. But I presented a plea form signed by the state attorney and Mr. Ridge with the terms that he finds acceptable and wants to enter today. So at this time, I'd like to step back from the podium and if you can
Okay.
go over the term.
Thank you.
Thanks, Judge.
Anything from the state?
No, sir.
Mr. Ridge, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Ridge, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Do you have any questions for the court or the state?
Only for my transfer bond, they said that I would have to pay another $100, and I don't have the 100. So
No,
that,
you will not have to pay another 100. Your first 100 is still, because it hasn't been that long, right? It was just last month or a couple
like
weeks
2
ago.
weeks ago.
Okay, yeah, no, the $100 is still active for this transfer. We're just gonna add it to the case.
Okay,
So you're
thank
good to go.
Thank you, thank you.
Okay. So other than, were you put on probation for 24 months?
Yes, sir.
Okay. So the only downside is you'll have to pay the court cost, and there's not a $150 public defender's fee. So do you understand that you're waiving your right to a trial by jury?
Yes, sir.
Okay. I do accept your plea. Adjudication is withheld. Your probation in 24 CF 1892. You're sentenced to 24 months probation. That's concurrent with 23 CF 2219, 23 CF 2233, and 23 CF 2234. Count 1, it's 6 months concurrent. Count 2, it's concurrent online. Oh, you'll need to take the anti-theft course regarding count 2. And then you'll need to pay the $100 restitution to 3 dogs and a chick. And the address is on the plea agreement. So the 24 months, it's really, he's not sentenced to 24 months on this case?
Yes, it'd be 24 months on count 1, and then 6 months concurrent probation for count 2.
Got it. Thank you. Thank you. I knew that didn't make sense. Okay, so 24 months on count 1, 6 months on count 2. Both of those are run concurrently, run at the same time, and run at the same time as the cases with Judge Ketchell.
Yes, sir.
Okay? As far as the cost of supervision, you'll just have to pay that once for all of the probations, okay?
Yes, sir.
Thank you, sir.
Thank you. Oh, I do have another question.
Yes, sir, please.
When I went to jail, they took a certain amount of money. I asked to put a motion in to get it back. I didn't know if you guys got it or not.
As far as a bond amount,
Yes, ma'am. It was over $1,500, $2,000 to $1,500.
will they take that directly toward court costs?
No, it's not. It's not a cash bond, Judge. It's a surety bond. So.
Okay. So the premium you paid to the insurance company for that bond is gone.
Okay.
That was consideration paid to the insurance company. There's no cash that's there.
So the
To
money
be
that
returned.
I was arrested with, I can't get that back?
Oh, yes, sir.
Yeah.
And if that didn't have anything to do with the,
No, it didn't. I'm a barber. I cut hair, and it was that was my rent money, so.
Mr. Snell, as far as the money that,
So that's, I haven't heard of that yet, till just now.
Just let him get his money back. Just let him get his money back.
I'm cool with that. I just came all the way down here from Houston, Texas, so I just And I've been calling to get the money back.
I wouldn't have any reason to think that it should be forfeited, so.
Okay, so if you'll put in the minutes that any funds that were seized from Mr. Ridge will be returned to him, less any administrative fee. That's from the jail.
Do you know who seized it? Was it the jail that took it? Was it the sheriff's, was it?
Probably the
people that arrested
sheriff's.
you?
Right?
It was, I'm not sure. I called the
Here,
evidence.
okay, hold on one second.
Just because
Did
I feel
you,
like if it's the sheriff's office or PD, they're probably gonna need an order.
did you have it with you when you went to the jail?
Yes, sir. Yes, sir.
Okay. So I would think the
It's in the
jail,
evidence locker. It's in the evidence room.
No, well, then it's.
That's gonna need that's gonna need a motion for return of property, and then there's gonna need to be an order.
okay, well, I think he's orally making that motion.
Because
Yeah,
I've been,
I'll
me
need
and
an order from your office,
Okay.
Mr. Steve Medina, we put in a motion about a month or two ago.
Okay, he's who's representing you in.
Yes, sir.
Okay. Stay in touch with him.
Okay.
Tell him to add my case number on there if needed.
Okay.
And I'll sign an order for that, at least as far as my one case.
Okay.
Okay?
Thank you.
Good, thank you, sir. Ms. Williams? Mr. Williams?
You did issue it to Mr.
Okay, thank you. Mr. Williams, why weren't you here earlier?
I was at work and just kind of lost track. I was working out in Chatham.
Okay,
I was running a little late.
if you'll give me one moment. You're pro se, you're representing yourself. Do you have an attorney?
I don't even think I'm in felony court
Okay,
as far as the charge, correct?
Wait,
It's a DWLS judge, but this is with a prior, so it's a felony.
okay.
I went to first appearance in Santa Rosa County, and the first appearance judge gave the state 24 hours to amend.
Do we know where Mr. Williams is on the 9 o'clock
On
docket?
the 130 docket.
1:30 docket, there you go. Arraignments, okay, good. Mr. Williams, let me just find. Got it. And you're Randy Williams,
Yes, sir.
correct?
Yes.
The KP is withdrawn from Mr. Williams. Does the state have an offer for Mr. Williams?
It's gonna be DOC, Your Honor.
Okay. Mr. Williams, do you want me to appoint a public defender if you qualify financially? It is a felony.
So what
Okay.
they did,
Don't say anything factually about your case.
right, what they did in the bond in first appearance in Santa Rosa is no good?
not here, not in Okaloosa County.
You did recall
Yes, ma'am.
to make sure.
And we don't need probation anymore, right?
That's
Okay. Thanks, probation.
Thank you, sir.
Thank you so much. So, Mr. Williams, do you want me to appoint an attorney to represent you?
Please, Your Honor, yes.
How much money do you make per month?
$2,000?
Okay. I do appoint the public defender to represent you. Mr. Kleins is on your left again.
Your attorney's name is gonna be Jason McKinney. All right. It's the same contact info though, so you can call this number and ask about him, okay? I'm gonna enter not guilty plea today, then I'm gonna ask.
Thank you.
Thank you, sir.
Your Honor, we will acknowledge receipt of a two-count information and waive the formal reading. Enter a not guilty plea and just ask that this remain on the November 12th docket.
Okay? Yes, sir. So I'll see you no later than November 12th. If the state offers you something you want to accept before that date, Mr. Kleins can set it for a hearing. Thank you.
Thank you, Your Honor.
Daniel Godwin never appeared, I take it?
No, he was on Zoom.
And then I put in the waiting room and then he disappeared.
That's great. Was he in the waiting, was that Florida State Hospital that he was at?
Yes.
Okay. Yeah,
He was in Florida State Hospital.
Okay, so we were trying to figure out why this was on, and we were assuming based on, I was looking at the record.
It's because nothing has happened for over a year.
Well, I think he's still in Florida State Hospital, so I don't think anything can happen.
Well, we need to have some kind of review, at least annually, instead of somebody being stuck there forever without popping up. So,
Do we want to go ahead and just reset it then for October to see
well,
if we can
what
get
I was
a-
thinking is, let's just make sure he's still not on.
Could-
If he's not, I think I need to appoint an attorney to represent him.
I think that would be the ideal. Daniel Godwin, it's a homicide. He's in,
Mr. Kleins,
he's in Florida State Hospital right now.
This is the individual that allegedly spit on my supervisor? Is that?
I have no
I
idea.
think this case started up in Crestview. I believe we withdrew.
That would make sense because it's Leah Glisson's case, ASA Glisson's case. I'm just kind of covering for it because we weren't quite sure.
If the court wants to appoint our office, obviously that's step one. We will
Yes,
look
sir.
into the withdrawal.
I do, and if you'll just make a note, the reason why I said it, he filed something himself, but there hasn't been any review for him in over a year. And
That's fine.
one of the doctors said more than a year ago that he thought competency would be restored in 6 months to a year. And we just haven't had, he's totally off the radar.
Hey, and I might be wrong. I knew there was somebody who got transferred down here on a recusal. But what's the case number, Madam Clerk? And I'll-
It's 20 CF 1515.
Okay, I will get to my office tomorrow morning and figure out what's going on with Mr.
Okay,
Godwin.
and then we'll just set it for a status, October 14th at 9 o'clock.
Yes, sir.
Thank you, Mr. Kleins.
Yes, sir.
Any,
Last I have is Mr. Michelmore.
I'm sorry,
please.
when was that set? I'm sorry.
August 14th.
October.
October
14th.
14th? Okay.
Yes, sir. October 14th, thank you. Hello, Mr. Michelmore.
How you doing, sir?
Good, how are you?
Doing all right.
Your Honor, this is Mr. Michelmore before the court on a motion for an order to show cause. We have attempted to depose Mr. Alvonta McRae several times. He is not responding to subpoenas. I believe the state subpoenaed him for today's hearing.
We tried to get up with him because we were trying to verify address. We've tried to get up with family members to try to see see if they knew where he was at. I believe at one point in time, we tried to get up, I don't want to misspeak, with his father to see if he had any contact. There was nothing. The last time that we did have contact, he had told us that he didn't want to help us out or to prosecute whatsoever. However, we were still given these charges, trying to move forward any way that we could. And so that's kind of where we're at now. I don't anticipate him being here today, so I understand the court is going to have to do what they have to do, and Mr. Kleins will probably move for what he has to move for, so.
Okay, well, here's, when I was doing my homework, Mr. Michelmore, because I've got to think about everybody being put on notice, and including Mr. McRae. So as I look at the return of service, it says, a person residing therein of who confirm the defendant resides at the above. I delivered the document to Marlene McRae, co-resident. And then the subpoena was for September 4th of 20. Okay, so that was the subpoena for the deposition, correct?
Correct, Your Honor.
Okay.
That was the second deposition subpoena that went out. The first one, he was not served because he couldn't be found.
Okay, and so my note to myself says, no notice of this hearing was attempted to be sent to Mr. McRae. So why wouldn't Mr. McRae need to be noticed of this hearing?
Well, this is a motion for an order to show cause, so we're asking the court to issue an order ordering Mr. McRae to come into court to explain to the court why he's not complying with the
But
subpoena.
traditionally, due process would say you would give them notice of this hearing too.
Well, the problem is that when we have served him a subpoena through substitute service and he doesn't show, I mean, it was for a Zoom deposition too. It wasn't even requiring him to travel anywhere.
Right. I am going to grant it, and I'll enter that order, but in the future, on the notice of hearing, at least mail a copy to the proposed deponent at wherever they were served.
Okay, we can do that.
And, okay, so the notice of hearing, I know we're not doing something without that person being here or having notice.
I would also point out that the state has had contact with Mr. McCray. He is aware that this is a pending case over here. It sure seems to me that he's attempting, I mean, Mr. Gomez just said he's essentially flat out told the state, I don't want to participate. So I understand what the court's saying, and certainly in the future, we'll go ahead and do that, but
Yes, sir.
I would ask the court to issue that order and order.
I will
Mr.
enter
McCray.
an order to show cause. When do you want to set it for?
First available date, Your Honor, in October
Well, we need to
10th.
give time to serve him with it, right?
Well, I mean,
I think 10/21 would be literally a month.
Okay, let's do that at
Or we
9
could, I
o'clock.
mean, the earliest date, the other earliest date would be October.
I would ask for October 14th. I mean, that's.
I'm okay with October 14th.
That's 3
Well,
weeks from today.
Before I put somebody in jail, I'm doing it where they dang sure have to have notice of that hearing.
Understood.
And so it's got to be served by a sheriff, by a deputy,
In Mississippi.
and that's not going to happen by October 14th, I doubt.
Well, I mean,
You got to get me the order. And in Wiggins, Mississippi.
if the court wants to put it on October 21st,
You
that's
want to do
okay.
it, why don't we split the baby and say October 17th?
That's fine, Your Honor.
Okay.
I can't tell the court that I know Mr. Michelmore wants me to make a tennis motion to reduce the bond in this case. Just so the court's aware, there were 2 individuals on this video. Well, there's 3 individuals. There's the person who fired the shots, and then there's Mr. McCray and another witness. That witness has come in and testified at her deposition under oath. She doesn't remember anything about what happened that night. Mr. McCray looks like sure looks to me like he's trying to not be involved in this. I would argue to the court, at least at this point, that that's a substantial change in circumstances for Mr. Michelmore. I know he's previously asked the court to consider putting him out into the community. Given the fact that this case is a year old. He was arrested October 30th last year. So we would ask the court to consider an Ortennis motion to reduce that bond to a signature bond.
To the state.
Candidly, Your Honor, this is tough for the state because I understand that Mr. McCray has represented to us that he's not trying to help us. We're trying to prove this case in every other possible way that we can, and so we're actively trying to look into that. Given the charges, and I mean, the state feels that there's a lot of other things that go into knowing that this is Mr. Michelmore on the video. There are statements by the officer. Officer would testify that he received a phone call from somebody that he knew was Mr. Michelmore shortly after, talking about facts of this case that only the person in the video would have known. There is a surveillance video that the law enforcement believes accurately identifies Mr. Michelmore as the shooter in this situation. I can't speak for the veracity of whether or not Ms. Roof, or Ms. Miles, I'm sorry, actually doesn't remember anything. I mean, on the video it shows this witness being directly in the middle of these 2 individuals when the gunshots go off. Given that this charge is something as serious as an attempted second-degree murder, we would respectfully request that this bond remain in place, Your Honor.
Okay.
I believe Mr. Michelmore wants to address the court, understanding that anything he says can be used against him.
Yeah.
Yes, sir.
You know, October 30th, I turned myself in for questioning because I heard I was a person of interest. But when the investigator came to talk to me, I refused to speak to him because it was conflict of interest. I already had an open case with this deputy that lied on an oath that Larissa Dudley will represent me on the case. The deputy is named Brandon Simpkins. You know, my name came up. When I heard about my name coming up, I immediately got my mother-in-law to take me to the jail. I didn't know that I had to go to Shalimar, but I ended up going to Crestview. I didn't know that I was gonna get charged. I've been in this area for 20 years, Your Honor. I got people that can vouch for me. I never been in no violent crime. I talk to my 3-year-old every night. His birthday next week on the it's on the 30th in 11 days. He asks me every night, Daddy, when you coming home?
Let me ask the state. Mr. Michelmore have any other record?
Hold on, Your Honor.
Your Honor, if I could chime in, I could.
Sure,
Score sheet,
please.
according to the score sheet, he has 5 prior possession convictions, 1 sale, manufacture, delivery, 6 misdemeanors, and possession of a firearm, I'm assuming by a convicted felon. But I don't know the offense dates for that stuff.
That sounds accurate, Your Honor.
Okay. Mr. Michelmore, you make a really good argument. Respectfully, I'm not going to grant it today. I will see you on October 17th, okay? Thank you, sir.
And Rusty, I'll come up to the jail. Your Honor, in full candor, I might file a bond motion for October 10th, but I need to talk to Mr. McLemore before I do that.
Okay, thank you.
In that hearing on the 17th, Your Honor, is that at 9 o'clock?
It's order to show cause? Do we need to have it in the afternoon? Or
I think so. I don't, just leave it for now.
I'll defer to the state on the time.
9 o'clock?
9 o'clock, please.
Thank you.
All right, Rusty. I'll probably see you next week, okay?
Yes, sir.
Your Honor, I believe that's all I have. Excuse me.
Yes, sir. Do we have Miller left? Nope.
We